Prosecutor Shanlon and former police chief Cedric Alexander. Cedric, when we're talking about the use of force, is it right that there's no blanket definition for what's acceptable and what is not acceptable? The witnesses today said the appropriate use of force changes based on every situation and every suspect. That might help Chauvin's defense.
Well, the key about this is that certainly every incident is very, very different. But the reality of it is that you have 9 minutes and 29 seconds of video there that demonstrates or suggests something very different, I think, to people when they see it. The whole idea here in all of this is yes, training can be very specific, but it also can be very useful if used correctly and with the right intent. And I think thus far what we all have seen are witnesses who have come and who have testified. Those are experts in their areas who have testified that what they did on May 25th was not appropriate to any of their training, even in this particular case that we all had an opportunity to witness. So I don't, to my observation to this, the defense is doing their job, but I don't think they scored that high of points when you consider all evidence that has been put before the court so far now.
All right, interesting. Shan, I want to get your reaction to what the use of force instructor said today, specifically about neck restraints in terms of the Minneapolis Police Department, or MPD. Take a listen.
Does MPD train on how to do it with a leg?
We may show the younger officers in the academy what that looks like, but we don't train leg neck restraints with the officers in service. And as far as my knowledge, we never have.
That seemed pretty important for the prosecution.
It is, Jake, and I think the way this is going, it's pretty clear that the bulk of the expert testimony is going to be that Chauvin did violate police procedure and training in this circumstance. I agree with Cedric that the defense made some points today. Their point of view is that there's exceptions to everything. It's an evolving, fluid circumstance. I think the difficulty for that point that they're making is all of that really compelling eyewitness testimony. Those folks don't come across as really hostile, obstructionist crowd. It'll be interesting to see whether the prosecution recalls any of them later in the rebuttal case. If they do, that might signal the prosecution thinks the defense scored some points too.
And Cedric, the testimony today fit into a larger pattern that we've heard from the prosecution that Derek Chauvin, he not only went outside his training, he went against his training, as well as against the guidelines of the police department in his use of force against George Floyd. There is, of course, a difference between breaking work rules and knowingly committing murder. That designation is going to be up to the jury.
Well, certainly it will be, but I think one thing that is very clear here, and it's already been stated, articulated, and pointed out by those who are experts in their fields, that everything that Chauvin did on that day, he was not taught, particularly when they got Mr. Floyd down on the ground, pinned him down the way that they did. And we also have to remember this, too. In all of this that we're hearing, Chauvin was not there by himself. He had 3 other officers there with him, 2 that were down at the legs. So they had an opportunity, quite frankly, to make sure that George Floyd had an opportunity to breathe, whether they believed it or not. Because if you can remember, even Officer Lane said to Chauvin, shouldn't we turn him over? So even Lane had some doubt in what was happening, but of course Chauvin said no. So I don't think that the defense scored any real points here today, because here again, the overwhelming testimony that we have heard really is pretty straightforward, but we're going to see as this trial continues.
And Shane, as we hear all of these witnesses talking about Derek Chauvin's behavior and his training, do you think the defense is considering letting Chauvin testify? As a defense attorney, would you let him take the stand?
No, I wouldn't. It's tempting, particularly in a police officer case, because we know that jurors tend to sympathize with the police, don't want to convict them, so it's much more tempting than a regular defendant situation where usually if you put your client on as defendant, they're just going to get sliced and diced. Here, however, I wouldn't do it because his reputation, even his demeanor in the courtroom, is not very sympathetic. There are very charismatic defendants who can win a jury's sympathy just by sitting there, O.J. Simpson, for example, but he's not one of them. I think he's coming across as pretty cold. His reputation is that he comes across as cold, I think he would not do himself any favors by testifying, so I wouldn't call him.
Cedric, even if the defense convinces the jury that this was an acceptable, allowable use of force, they're still going to have to explain why none of the officers on the scene gave Mr. Floyd any medical aid. Have you heard any good reasons so far as to why that aid was never given?
No, I have not. And even when I put myself, and I think back over the course of my career, in situations where we had to wrestle someone to a ground, we always remembered one thing, and that is we still were responsible for the safety of that person even once we had them in custody. So I don't think anything has been presented here so far that has been compelling enough on a defense side. But here again, there's still a lot of testimony that's coming forward over the next couple of weeks.
Yeah, we're just at the beginning of this. Shan Wu, Cedric Alexander, thanks to both of you for your expertise. Appreciate it. Any moment